my name's Holli Sargeant. I'm a postdoctoral researcher at Cambridge. I'm really happy today to be presenting my paper with my now former PhD advisor, Måns Magnusson, a statistician from Uppsala, who's here in the front row as well. This is a really fun interdisciplinary project which came out of a lot of conversations in which we realized we were using similar language to describe different things. I'm sure all of you have had a similar experience of interdisciplinary research. So we've tried to sit this paper really at the intersection of law and statistics and machine learning, but really trying to evaluate a lot of the technical algorithmic fairness or fair ML literature that looks at issues of unfairness but often conflates them with discrimination. And how would we actually implement a lot of these technical tools in a setting for trying to prove unlawful discrimination, in particular outside of the US? So one of the things that our paper tries to do is deal with three misconceptions that we identify in the literature as they extend to law. The first one is that, as is necessary in many of these technical papers, there are certain assumptions that have to be made to be able to progress through the proofs. But ideas such as assuming a data generating process or assuming causal structures are known or having kind of no uncertainty or different types of issues like that, while they make sense in technical settings, they actually will have real implications in a legal setting. So jumping past some of those assumptions to begin with is going to have flow-on effects for how we might actually think about these issues in a legal evaluation, and I'll give you an example of those today. The second one is a huge over-reliance on parity. Thank you, Alex, for setting up some of my presentation. It's always nice when that happens, where the reliance on these technical parity-based metrics are a useful tool, and I'll describe where I think they fit well in a legal evaluation. But statements such as, because there is demographic disparity, there is discrimination, don't make a huge amount of sense in a functional legal setting. It's like saying someone was killed, therefore it was murder. Well, there are lots of conditions in which someone is killed which isn't going to meet the legal definition of murder. And although the joke at lawyers' expense is often, oh, well, it depends. No, we know what it depends upon. And what we're trying to do in this paper is actually tell you what it does depend upon. One of the other things that we try to deal with, I think, is a huge US dominance of this literature. This is a rant that I can happily go on for many more minutes than 9, but I think while an interesting and important and complicated area of the law, the US is actually the outlier in discrimination law across the world, particularly when you're looking at English-speaking, common law, liberal democracies, and even well beyond that. So our paper looks specifically at UK law. I'm at Cambridge, but also I'm an Australian lawyer, and the Australian and UK systems are almost identical as a current Commonwealth, but as a former part of the British legal system. But that's true not just of Australia, Canada, New Zealand, it's also Bangladesh, Singapore, South Africa. So many other countries have a system that's quite distinct from the US. And I think it's not just an interesting academic comparative law debate that I enjoy having, it's actually going to leave real liability gaps, where if a model is built to be compliant with discrimination laws in the US and it's applied in the UK, it's going to meet definitions for discrimination law. So you don't just have liability for companies, you have real risks for individuals as well. So the way we approach this in the paper is taking what I call a functional analysis of anti-discrimination law, where we're trying to get back from the doctrine of just what is the definition and what does the statute say about discrimination, but how would you actually go about proving it in a court? And so we break this down by saying, well, not just how do you define unlawful discrimination, which is often where these papers start, but also what are the instances in which it can be justified, because there are more than are often acknowledged. How do you actually go about proving it? Issues such as causation and evidence. And then what are some of the excuses for discrimination law and where does that become important in these settings? So I would say a lot of technical fairness literature sits either in this first step of sort of the definition of unlawful discrimination, people are treated differently based on a protected attribute, or they sit more in the proving section of how do you get statistical evidence of a disparity. But without kind of considering all of these issues as a whole, I think we're missing quite a few important things. And the connection that we make in this paper is hopefully something that can help improve the design of machine learning models. So we break down a decision theoretic approach of where does the discriminant actually come from and what are some of the choices that people make in designing algorithms that result in these discriminatory outcomes. This is not just a question of your model is biased. Why is it biased? Where did it come from? Was it poor data curation? Was it setting different thresholds for different groups? Was it defining a utility threshold that doesn't make sense in certain contexts? So I wanted to focus on one of the core contributions of the paper today, and this is where I was mentioning at the beginning issues of technical assumptions that kind of miss some of the extra reasoning and discussion that we need to have as lawyers. There's a difference between what we would expect a true model to produce and an estimated model. So if we were to take something like a statistical parity metric that says, well, people are treated differently based on their gender, it's interesting to understand, well, is that reflecting a true real-world disparity? And that's when we have our legal discussion. Sometimes those true differences between people are valid. Law has never required all people to always be treated equally. That doesn't make sense in our legal system. But then there are some cases where we do protect them even though there are true differences that arise, and that's often the purpose of anti-discrimination law. But it's important then to also think about, well, what happens when you have an estimated model that introduces a large amount of estimation error and it is not reflective of a real world scenario? And so that's when we start to have this more interesting analysis of, well, where was that estimation error introducing this bias or discrimination? Is it because of the differences in design, in the decision thresholds? Is it because of differences in your data curation? And we try to connect these through the different stages in the paper. So we use a case study in the paper for our framework to try and show how it might be applied in a real-world setting. I'm sure some of you have heard of this Finnish algorithmic credit discrimination case. It's a few years old now, but it's a helpful use case for us. It's a Finnish algorithmic creditworthiness model, which is for online payday lending. And I wonder if any of you in the room already see a red flag, which in US law, the idea that your input variables include protected attributes would be something that we would be worried about. We're not worried about that in law outside of the US. It's perfectly legitimate in the UK and in Finland to have protected attributes as part of your data set and your models. We're interested in what the effects are of those. So the way that we think about reasoning this difference between a true model and the estimated model is by thinking about whether or not a protected variable would actually influence the true model. So is there an actual valid reason that it affects the creditworthiness of someone? And so we can assume for this setting that we have a differential treatment for people with protected characteristics, and let's say it shows a statistical disparity, or even let's say we condition it for credit score and we still have a conditional statistical disparity or conditional demographic parity. Many current formulations in algorithmic fairness would say that this is discriminatory, but our more important question is, well, is it unlawful? And so in trying to understand that question, we look at how it might improve the predictive performance of a true model. So credit being our example here, what are the real variables that actually influence whether or not you're likely to get a loan? And then we have a secondary question of, is that a protected characteristic that's protected by law regardless? So whether or not there's an estimation error introduced, and we formalize this in detail in the paper, sorry for kind of skipping past some of these issues, but we're looking at whether or not there's, and we call it a conditional estimation parity metric, whether or not it can be a legitimate part of the model. So to formalize this, let's go through two examples. And I have selected two that are not race or gender, despite their dominance in literature. There are many protected attributes that are often more difficult to think about. So age is a good example, right? Let's say, does age, even though it's a protected attribute, be a legitimate variable for young persons with limited credit history? Is it something that we should consider as a true risk in making a creditworthiness assessment? And we reason about this in the paper and say, well, yes, it does, because you have drastically different abilities to repay if you're an 18-year-old or if you're a 55-year-old. We know this, so we consider that legitimate through the consideration of a true data generating process. And conveniently, for this example that I've selected, it also happens to be lawful, because lawyers have acknowledged that true difference and actually implemented a statutory exception for age to be used as a legitimate variable. So it's an exception to direct discrimination for age in credit and other financial decisions in the UK and in Finland. An alternative example is something like first language. So while that's a less common protected attribute in some countries, in the Finnish case, we have a protected attribute for what your first language or your mother tongue is, whether you're Finnish-speaking or, for example, the minority Swedish-speaking part of the population. In that case, there were quite significant differences between those two population groups, and then our question becomes, well, does your first language have correlations to the credit risk? And while in their case they showed that there was some predictive value, there was a correlation, there was information that showed that there is a difference in outcomes, it wasn't because of first language. So again, part of this is statistics and part of this is legal reasoning and understanding the cultural context we're talking about, which is that that was picking up on other socioeconomic factors that exist in Finland that had nothing to do with your language, but everything to do with other contexts. That if you had more and better information about actual financial positions and didn't just use population-based data, you would have had a more accurate model. So we call it both unlegitimate, illegitimate for its application in the model, but also it's unlawful as a protected attribute with no justification either. So I'll leave this up here, but just to mention very briefly, some of the things that we bring out of the paper in our recommendations are using this type of reasoning method to both justify your aim and your input variables when you're approximating a true model, thinking about ways to minimize estimation error, using that to help actually assess your group differences, not just identifying a group difference and moving on. And I think where I end almost all of my presentations, to be able to do all of that, engaging true interdisciplinary expertise. So thank you so much. Happy to answer questions now or later as well.